In 2005, the Indian state underwent a structural reversal. Decades of classified physical files were suddenly subjected to a legal mandate of public access. For over a century, governance was shielded by the Official Secrets Act of 1923. Enacted by the British Raj, it was an instrument designed to protect the administration from the scrutiny of its subjects. Under this 1923 legislation, withholding information was the absolute legal default. Bureaucrats could routinely deny access to public records under the broad guise of state confidentiality. The Right to Information Act of 2005 stands as the direct antithesis to that colonial logic. The RTI Act inverted the paradigm. It established transparency as the default and made secrecy a narrow, legally defined exception. This shift began at the grassroots. In the 1990s, the MKSS movement in Rajasthan began demanding access to muster rolls and bills to expose corruption in rural wage payments. Their slogan, "Our money, our account," marked the first time people moved from subjects to sovereign citizens. By institutionalizing this demand, the RTI Act created a structural transfer of power, giving the public a legal mechanism to audit the state. The 2005 Act did not create the citizen's right to know out of thin air. Long before the statute existed, the Supreme Court of India ruled that the right to information was already woven into the fabric of the Constitution. In 1975, the court determined that freedom of speech, guaranteed by Article 19(1)(a), is hollow if citizens lack data to form an informed opinion. It also tied this right to Article 21. Accessing state records on public health, food distribution, and environmental safety is often the only way to protect an individual's personal liberty and life. However, there is a natural institutional conflict. Bureaucracies inherently resist sharing the data that constitutes their ultimate power. To overcome this resistance, the RTI Act forces every request through a rigid three-gate legal algorithm. This provides the constitutional right with a strict statutory machine that forces the state to comply. To understand how the law works, we can map it as a sequence of three testing gates. Gate 1 is the definition and threshold test. Here, the public information officer determines if the law even applies. Under Section 2H, the target must be a public authority. This includes any body created by the Constitution or by law, as well as entities owned, controlled, or substantially financed by the government. This means the law's reach extends past traditional ministries to include non-governmental organizations that receive significant state funding. The reach of this gate was tested in 2019, when the Supreme Court addressed whether the judiciary itself is a public authority. The court ruled that the Office of the Chief Justice of India falls under Section 2H. However, it set a boundary. While the administrative side of the court is open, the internal judicial logic, how a judge thinks, remains protected. Gate 1 also checks the information payload. Under Section 2F, the request must target existing records. An officer is required to provide the data they hold, but they are not bound to generate new answers or explain why a policy was made. Gate 1 establishes jurisdiction, ensuring the state cannot hide behind claims of institutional exceptionalism. Once a request clears the threshold, it enters Gate 2, the exemption test. This is where the right to know is weighed against specific protected interests. Section 8(1) defines the only legal grounds for withholding data. These include threats to national security, the exposure of trade secrets, and under Subclause J, unwarranted invasions of personal privacy. Bureaucrats often misapply these hurdles. One common tactic is to reject a request by claiming the matter is sub judice or pending in court. But the law is specific. A pending trial does not trigger an exemption. An officer can only refuse the data if a judge has issued an explicit order prohibiting its publication. Gate 2 also handles third-party data under Section 11. If the request involves confidential information originally supplied by a private company or individual, the officer must follow a 40-day notice procedure, giving that third party a chance to be heard before the data is released. Gate 2 is the legal friction point, balancing an individual's right to data against the collective need for security and privacy. If a request is blocked at Gate 2, the law provides Gate 3, the overrides. These provisions are designed to ensure that the general rule of transparency takes precedence over secrecy. The first override is the principle of severability under Section 10. An officer cannot reject an entire file because it contains one sensitive paragraph. They are legally bound to redact the exempt data and release the rest of the document to the citizen. The second override is the most powerful, the public interest override in Section 8.2. This establishes a balancing test. Even if information is technically exempt, the state must disclose it if the public benefit, such as exposing financial corruption or a health risk, outweighs the harm to the protected interest. To ensure these overrides work, the Act includes Section 22, the non obstante clause. Section 22 establishes that the RTI Act takes precedence over the Official Secrets Act. If a document is requested and does not fall under an RTI exemption, any conflicting rule of colonial-era secrecy is rendered legally invalid. Gate 3 acts as the ultimate safeguard, ensuring transparency wins whenever the public good requires it. A legal framework is only as strong as its enforcement. The statute forces bureaucrats to execute this logic through personal liability. Public information officers, or PIOs, must adhere to non-negotiable timelines, typically a maximum of 30 days to provide the information or a valid rejection. If the request concerns an individual's immediate life or liberty, that deadline drops to 48 hours. Under Section 20, the Act provides the consequences for failure. The financial penalty for an unjustified delay is personal. A PIO faces a fine of 250 rupees per day, up to 25,000 rupees, which is deducted directly from their personal salary. If a citizen is unsatisfied, they can appeal to a senior officer, and finally to the Independent Information Commissions. These commissions have the powers of a civil court. They can summon records, examine evidence under oath, and force compliance from recalcitrant departments. By shifting the liability to the individual officer, the law creates a powerful deterrent against stonewalling. In the real world, the RTI Act serves as a permanent, decentralized social audit, allowing citizens to check the math of their own government. But the operational reality of the Act is currently facing systemic threats. Appeal backlogs have reached a critical level. When the government delays appointing information commissioners, the second appeal window can stretch for years, rendering the information obsolete before it is ever received. There is also a modern legal collision with the Digital Personal Data Protection, or DPDP Act. By amending Section 8(1)J of the RTI Act, the DPDP legislation creates a severe privacy versus transparency dilemma. The risk is that broad privacy clauses could be used to shield public servant data, like recruitment records or public spending logs, from citizen scrutiny. Transparency is never a permanent fixture. It is under constant threat of regulatory rollback. Transparency in governance is not a passive state graciously granted by the state. The three-gate matrix of the RTI Act exists because, in any bureaucracy, accountability must be actively extracted. In the balance between state secrecy and citizen sovereignty, the law must forever default to the public's right to know.